Any mention?
May I please, Lordship? Lordship, we beg to make a joint mention of item 20. Your Lordship, here the settlement process is going on, Your Lordship.
Number?
20.
20, you see that? 20. Yam Kumari Tamang.
Yes, Your Lordship.
There's talks settlement. You're there
Yes, Your
also?
Lordship.
After 3 weeks, as talks of settlement are on.
Obliged, Lordship.
Also, petitions participate as to that's all. Yes.
Please, Lordship, I beg to mention item number 18, my Lord. This is for hearing due to some personal difficulties I'm mentioning.
Yes. What personal difficulty? Not ready for hearing?
It's not yet, Lordship. I have informed the other party also, Lordship.
1 week, yes.
Lordship. Much blessed, Lordship.
Yes, Mr.
I
Sheikh.
beg to mention item number 28, Lordship, 28.
Who?
28.
Yes. Johnny Marbo.
Yes, Lordship. 2 weeks, Lordship.
My Lord, I have no objections.
2 weeks.
Much.
28. Yes.
My Lord, I beg to make a mention of item number 1 from the daily list. Item number 1 from the daily list. On behalf of Learned Advocate General, I pray if the matter can come up.
Of the?
Daily list, Lord. Item
You're not
1.
supposed to mention daily list on any account.
My apologies.
Do I have to keep on saying it all the time? Let it be called out? Yes.
Your Lordship, I beg to mention item number 22.
22.
Yes,
You're on a
Your Lordship.
petitioner side.
Yes, Your Lordship.
Yes.
The conducting counsel is not available today.
Who's conducting counsel?
Sir S. Pandey.
How much time?
2 weeks, Your Lordship.
2 weeks. Enough? Okay, 2 weeks, yes.
Oh,
Sir,
thank
I
you,
was
Your
also
Lordship.
praying for 19 and 30, my Lord.
19?
And 30.
19? Vinay Kumar, whose other side?
Mr. Jha is there. And 30
19,
also.
20.
19 and 30, my Lord.
19 and
30. 30.
30. After?
So after 3 weeks.
What about the petitioner in 30? Mr. Paul is here.
30, Mr. Paul. 30, it takes some time.
Okay, 32 weeks, sir. And 19, 1 week, yes.
2 or 3 weeks.
Balance.
My Lord, I beg to mention item number 31 and 32. We seek time, my Lord. We seek time because the conducting counsel is out of station for respondent 6.
You're appealing for on whose behalf?
Obang, respondent 6.
For the private respondent, Your Lordship, those who have been appointed.
31. You have objection?
No objection, Your Lordship.
31, 32.
Yes, yes, Lordship.
After 2 weeks, okay.
Much obliged.
Yes. Yes.
May I please, Lordship? Your Lordship, we are making a joint prayer for item number 29, Your Lordship.
Transtarmi.
Yes, Your Lordship. I'm for respondent number 7, Your Lordship.
For the petitioner, Your
No
Lordship.
objection.
No objection, Your Lordship.
Yes, Nushulai. 2 weeks, yes. Yes.
Supplementary list, item number 1.
Yes, Mr.
May I please,
Sumar.
Lordship. This is, I'm here the contractor, Lordship. Professional contractor where I have constructed
You are
the
a?
whole contractor. They have given the 4 separate contract to the petitioner.
Given?
Tender, the work order on the separately. And then the amount is due around 6,60,300. That out of that they have paid only 60,000. Rest of the money is still pending with this state respondent. And that also on this construction was done at the time of when the country was battling for COVID-19. They have instructed me to complete all the process of work within period of 1 month. I have complete all the work. Lordship.
The bills are certified. you have
Certify because I have in the clearly mentioned in my para 9 that they have make a spot inquiry.
No. Have you annexed any?
Lordship, I have stated because
they have agreed that they have to pay.
Lordship, I'll come to that because in my para I have specifically stated that they make a spot inquiry. Usually they used to issue the certificate, but at that time of COVID-19 they have come. The respondent have come and make a spot inquiry. After that, after making a spot inquiry, they have reported the matter, complete recent report to the authority, and they have paid the money also 60,000. Then after that, they have stopped, my lord. That's why now the pending bill is still.
Let's see what documents you have annexed.
Yes, I have annexed only the tender work order, lordship.
No, I mean, see, you come by 226. You have to show that
yes,
whatever work you have done, the bills have been certified. And they are not paid to you.
But
otherwise, if you come with this is a civil.
Yes,
I mean,
lordship, if they are disputing, then I will definitely I will abide for the civil remedy. At this moment, let them clarify from the department. But
what work was this repair?
Yes, lordship. The detail in the para 2 I have mentioned the detailed work, lordship.
But see, but the thing is that annual repair, office health engineer, Tura, repair soil pipe, clean up septic tank.
Yes, all this
79,000. Then what other work?
Then the one, the first 1,79,000. Another one is 1,40,000. Then the third contract was sum of rupees 1,94,000.
It's not one work. It's
yes.
Repair of damaged veranda.
Yes, that. Yes, lordship.
No, that means there are many. There are small work orders.
Yes, small work orders. I have enclosed it in the annexure, page 16 till page 27.
So all these
all
works,
work orders.
all these works, the
yes,
total is 6,60,000.
Yes, all these works. 6,66,000.
Repair bathroom,
yes,
toilet.
Yes.
Ceiling.
They are not denying, lordship. Yes.
You really won't issue notice anyway. Since you're a small contractor, you should not. If you've done the work, yes, heard Mr. P.T. Sangma, like council petition issue notice, Mr. Khan, except on behalf all respondents.
All respondents.
No call for list after 3 weeks for different instructions.
Lordship. First place, lordship.
Item number 2.
My lord, this is a custom seizure case of 35 empty metal nut.
Of
35 empty metal nut.
Metal nut?
Yes, seized by Commissioner Custom on 15/1/2016. The case was decided in my favor by the tribunal as well as by the Honorable Court, but the appellate order has not been implemented by the respondent number 1, Commissioner Customs. And
why not implemented?
And this para 8 of this
beetle nuts are still there. They've been destroyed.
No, it is kept in State Bank sale proceeds. I refer my lord page 63.
It's a gold seizure.
Already been sold.
No, not sold. That is it is sold. It is a sale proceeds kept in the State Bank.
How much the sale proceeds?
66 lakh something.
Is lying State Bank.
It is in the SBI. Now I refer my lord this Honorable Court Division Bench order at page 63, para 8.
Page 63. 63.
63.
The operative part. Para 8.
This is the operative part.
Okay.
Last.
Okay.
In such circumstances, as stated above, we are unable to grant such relief to the writ petitioner as paid for. However, the writ petitioner is always at liberty to approach the competent civil forum in order to establish his claim of rightful ownership in respect of the seized battle nuts, which were later publicly auctioned. In the event the writ petitioner is able to obtain a decree from the competent civil court, it will be open to the writ petitioner to approach the customs authorities.
So what happened? You filed a suit?
Yes, I filed the...
So what happened after the suit?
After filing, I have filed the suit. Then
when you filed it?
On 4/7/2020.
Okay.
Then it is at page 65.
Okay, yes.
Title suit was rejected on the ground of ATCPC notice. We have submitted that it is not required because this case is referred by the High Court. The respondent has appeared with the tribunal and High Court and everywhere. So it is this may be dispensed.
What happened to the suit?
But court has not agreed. It was plaint was returned. Then I give the formal notice and I filed a fresh suit of at page 67, 2 of 22.
Then what happened?
But the case has not been progressed. So it is my humble money.
Are you appearing the suit?
Yes,
I
responding.
mean, not you, I mean, as a
yes,
Department of
appearing, state government.
What stage is it?
It is in the framing of issues. Framing of issues in
Why
2000
have you come here now for expeditious trial?
for expeditious disposal of the case. Time frame may be given to the
Time period we can't. Supreme Court
Civil matter.
then,
Civil matter.
but
How many
expeditious.
How many witnesses do you have?
My lord,
How many witnesses do you have?
we have witnesses.
How many?
That has not yet come. No, evidence has not yet come.
Just you have to know how many witnesses you have.
No, we have to give. But
You're filing for expeditious disposal. You want everything ready.
no, this is a that is a framing of issues that was in 2023, 17/3/2023.
When's the next date?
Next date in June.
Then
4 June. Now this is 1 year, more than 1 year. The framing of issues, only framing of issues, not framed. We have given the suggested issues, but not yet framed. So that's
so
just.
what can we do, Mr.
So
Gupta?
just for expeditious disposal,
Yes, Dr. Mozika.
because otherwise it is not known when.
Initial stage now. Well, the issues have to frame, witnesses have to examine.
Yes.
At this stage,
So
Is it a question of spending 3-4 years after,
it is.
when did you file that written statement?
I filed
When
immediately.
was- now you file a suit again 22, right? Then, where's the order sheet of the suit? Where's the order sheet of the
Order
suit?
sheet I have not given.
Then, how do you want to show the court that there's been undue delay by not annexing the sequence of events? I know the petitioners eager to get whatever money is there in the bank, but it should be in the right approach to show that there has been undue delay, that the court has not been diligent enough in taking up a matter. That way, then every suit that's filed in 22, 23, they'll come rushing here. You take a call, you take instructions. This is matter after 1 week to enable the counsel petitioner to obtain proper instructions. Otherwise,
well, why this order was passed by this honourable court, my lord? Because the betel nut was not seized from his position. It was seized from a godown. That's why that observation came.
No,
he has to establish his right.
no, that is the civil court. That's why the division bench said, establish your right, and if you can take the money and go home.
Item number 3.
If not, where will the money go?
This case is safer, my lord. The money is there, still with us. The other cases are already destroyed.
But he is not getting, his money is blocked.
Obliged.
My lord.
What is this? Gabriel.
Around 4 prayers, which are all interconnected. Basically, I'm aggrieved by the, firstly by the non-supply of documents, my lord, relied upon by them, and the documents which are...
Department proceedings are already commenced.
Commenced, my lord. The disciplinary proceedings commenced...
You haven't filed your detailed written statement also?
No, my lord, because till date, the documents have not been supplied to me.
When did it commence?
My lord, this commenced in October 2022. Your lordships will find at page 26. October 22. Now, in between, my lord, I've been requesting for the documents to be supplied.
26, 17 October, government, okay.
Now, my lord, page 260. If your lordships come directly to page 260, my lord, without wasting time, my lord, an extra 50, an extra 50, page 260. Now, my lord, this is a letter issued by the department, my lord, to me. And your lordships will see in the column, my lord, on the right side, most of the documents have been my lord, declined to be supplied to me on the ground that investigation is pending, my lord. Now, in disciplinary proceedings, my lord, this cannot be a ground.
No, but then the investigation is over now.
My lord, trial has commenced in all the cases. Lord. At this stage, I only pray for notice. Let them reply.
Let me have instruction, Your Lordship. I was told that he was called on 13 May, Your Lordship.
Exonerated?
For no, Your Lordship, for this document and all. Let me have instruction, Your Lordship.
Mr. Criminal Counsel Petitioner issue notice. Mr. Andy Shulai with MS and AAG with MS Arkolni is present except for the couple respondents. No
124, Your Lordship.
List the matter after
3 weeks, Your Lordship.
2 weeks for instructions for affidavit. Yes.
Lordship. Highly apply, Your Lordship.
Item number 4.
What instructions have been received?
Oh, supplementary. Oh, sorry, Your Lordship.
Why this court was terse last time is that it's just you can, when the court asks for instruction regarding suspension, you can't just stand up and say we have no instructions. That is.
I apologize, Lordship. I was on my legs in the other courtroom. I'm
you.
handling
just
the
saying-
matter, Lordship.
I'm not saying that. I'm just saying that whoever counsel conducts it should, that is, instructions are not, there or not, they have to make sure, yes, what instructions you received.
Lordship, they have filed this writ petition citing certain allegations against the government, Lordship. Lordship, as per the Meghalaya Civil Services Discipline and Appeal Rules 2019, Lordship, at Rule 6, Sub-Rule 1, Clause C, Lordship, if I may read, Lordship,
Yes,
the competent authority or any authority in which it is subordinate or any other authority empowered by the governor in that behalf may place a government servant under suspension where a case against him in respect of any criminal offence is under investigation or trial, Lordship. As of now, Lordship, the case, the status of the NDPS case right now, we are not aware, Lordship. Neither have they mentioned it, Lordship, number one. Number two, Lordship, he has been given subsistence allowance till date. Nothing has been denied to him. Everything is going as per the procedure according to law.
If on suspension, whatever it is,
Lordship.
parallel proceedings are not, you can institute parallel proceedings. And it has the right to know what's happened. 2 years on suspension, no DP has been drawn up. That's the only thing.
Lordship,
Why?
DP was drawn up, Lordship. They have also mentioned in their writ petition that
So what's happened to the drawn proceeding then?
as per the DP, Lordship, we have a non-official communication actually because of the paucity of time, Lordship. Now, my Lord, the Department Disciplinary Committee consisting of 5 members, namely so-and-so, my Lord, and the sitting of the Disciplinary Committee was held on 19/4/2023 at 3:30 in the office chamber of the Director, AHV, Meghalaya, and the Disciplinary Committee unanimously decided, since the case is pending with the court, hence the matter will be taken up as per court order, Lordship.
That's not an excuse. You file affidavit. No?
Lordship, we'll file affidavit accordingly, my Lord.
Instructions have been received today and are placed before the court by MSG, Senior GA. He is permitted to file an affidavit, bring the facts on affidavit. Yes.
Much obliged, Lordship.
Just after 2 weeks.
Daily list item number 1.
Yes. Now you can make your prayer.
Please, Your Lordship. Lordship, I'm making a...
Mr. Paul.
My lords, I am told, my lord.
It's in Times Square, so what are you going to do? When? When?
After 2 weeks, my lord.
When is he coming back? After 10 days?
Lordship.
In fact, there is some development, it appears.
We are also awaiting some instructions, my lords, on this.
To close the chapter. He's
Why
waiting for
is-
some written instruction.
Hidden instructions?
Written.
Oh, written instructions. Yes. I heard hidden, sorry. Yes, please pray the matter be adjourned for today in view of the absence of Advocate General, also on the prayer of the learned senior counsel for the petitioner to seek time to obtain instructions. List after 2 weeks. Yes. 2 weeks.
Much appreciated.
Item number 2.
We are filing it today, Your Lordship.
Which bullet points? Oh, the 711?
Yes. Order 711, Lordship.
Bullet points will receive matters reserved for orders. Yes.
Much obliged, Your Lordship.
Item number 3.
May I please, Your Lordship? Your Lordship, in this matter, we will not be filing rejoinder anymore, Your Lordship.
What's the matter about?
Akang matter, Your Lordship.
Listed for hearing?
Yes, my Lordship.
Parties pray that learned counsel for the petitioner submits that No rejoinder would be necessary. Only the matter for hearing on so and so.
Item number 4.
Also,
May I please, Your Lordship?
Mr. Panthi, where is the affidavit?
I'm praying for further week's time, my lord.
Why?
It has not been finalized, my lord. I just need, I'm waiting for some documents, my lord.
You entered appearance on?
Last date, my lord.
Yes.
Just a week's time, my
As
lord.
paid by Ms. S. Panthi, we have respondent number?
6, my lord.
6, further 2 weeks time granted.
1 week is fine.
Affidavit.
1 week is okay, my lord.
Take 2 weeks.
Obligation.
Abundant caution.
Lordship.
Yes.
Obligation.
Item number
Much
5.
obliged.
Lordship, in this matter, affidavits have been filed, my lord. Perusal of the affidavit shows, my lord, rejoinders are not really required. So matter can be fixed for hearing, my lord.
No urgency?
It's a fairly new matter, but there is urgency because it concerns the school, my lord.
Parties submit that, Mr. S. General Counsel for the petition submits that as no rejoinder will be necessary, the matter
for hearing.
Will be receive hearing. According to the matter for hearing, and so and so.
Item number 6.
Is supposed to get an instruction, Lordship,
May I please
because
give
here there is an order within 45 days that they will clear all the due. That is the order.
GHDC?
Yes.
Yes, Your Lordship.
Contempt?
Yes, Your Lordship.
It's been cleared?
No, Your Lordship. I humbly pray 2 weeks' time, Your Lordship, to obtain the instruction, Your Lordship.
No. How many times, when do you file this matter?
2024, Your Lordship.
9/4.
Yes, Your Lordship.
4/4.
9 April. On the last occasion, twice they have asked for instruction.
Because we have not received any instruction, Your Lordship, so I humbly pray, Your Lordship, and we need some...
Contempt matter, usually before contempt matters, before the High Court, notice goes every date the contempt has to appear. You ask Mr. Shulai, they are present in court.
Yes, Your Lordship, but
We don't want that to happen here.
last chance may be given, Your Lordship.
So many contempt applications pending here to keep that real behind there, like those production of accused. You don't want that to happen, no?
Yes, Your Lordship.
So MS and Raji, praise was allowed
2 weeks' time, Your Lordship.
2 weeks time to obtain instructions, spelling which personal appearance of the CEM. Okay, 2 weeks time, this time. Yes.
That's place, Lordship.
Item 7.
Lordship, this is as per the last order, the private respondent is supposed to get the instruction. Lordship, this is they have in the JHDC, the main respondent. Well, they have admitted that they will conduct the inquiry and they will they hold the election. So we I have in the last order also stated the petitioner is willing to take part. We have no problem with another inquiry, because the rule is very clear. The election has to be conducted.
What my friend is saying, that rule is clear. That rule does not speak about the election.
Lordship, may I take you the? I have enclosed the Lordship.
What instructions do you have?
Lordship, that inquiry is given, Lordship. After the inquiry, the district council can take a call, Lordship, based on the inquiry.
Then fine.
It can be disposed
Where
of.
the affidavit, Mr. Dev?
We have filed it on 25th April.
On?
On 25th April. Kindly have page 4 at paragraph 7.
Yes. You are Razul Karim?
Yes. My friend is relying on order from this court, whereby this honorable court has directed to conduct the election. That order was in different context, Lordship. Here the rule that Assam Land and Revenue Regulation rules does not speak about the election.
Yes.
Where the views of the wishes of the people, the views of the Mojata, and the family of the late Gaumura. My father was a Gaumura.
Yes.
That's also one of the considerations.
That's why I said that
While making a
wishes of the village, their entire village want
No,
the
but see, the thing
election.
is that if your villages obstruct the officers when you go for inquiry, then how can any, proper inquiry be done?
Both the parties.
You also obstructing?
No, Lordship. My supporter, your Lordship, I have
You also
enclosed
your
all the
supporters
annexure where there is no
obstructing. Your
evidence.
supporters obstructing.
I never obstructed Lordship.
Kindly have a look, annexure 2. This is the entire villages. There are around 300 villages who want to conduct the election. And
Why
my
obstructing the officers when they
because
win?
that even they are not able to speak who has exactly have the construction. If there is any people who is obstructing, what bar them to filing the FIR or taking the
FIR,
Lordship
these
here.
officers go to conduct the
Yes,
sport inquiry,
there is
and if you start making halagula, they go back.
There was no halagula, Lordship, from my side. I'm one of the candidate. This is another. They have conducted the inquiry also.
So we will make you sign a bond with the police also. before
Lordship,
the
I
inquiry.
am agree also,
You
Lordship.
will sign the bond to maintain peaceful conduct.
Lordship, definitely.
You are a
Provided there will be election. I have no
There
problem.
will be election. But
Lordship,
the thing is that
Lordship.
in sport inquiry be held, you undertake that any untoward incident you will be responsible.
Lordship, I will sign a bond also, no problem. Because
Yes, Mr. You also sign a bond.
I'll sign.
on the earlier occasion also, the officers already conduct the inquiry. See, Lordship, page 89, annexure 3. This is the GHTC officer. 3 officers they have went and they have conducted the spot inquiry, and they have given a view that there should be an election. It's there in that. It is there, Lordship, page 90.
If I may humbly submit, what has happened is the respondent's father was the previous Gaupura. He passed away. So the village was left without a Gaupura. There were 2 candidates, both the parties here. One party wanted election, one party wanted selection. So in view of the commotion, we could not hold the inquiry, and the report was that
One party won election, another one wanted selection.
yes, because he is the son of the, and he also has 300 signatures and more in his favor. They also have 300 signatures in their favor. It's a big village.
Oh no, that's the thing, exactly. This 90 doesn't say election. They said
Yes,
that they are objecting.
So in view
Some
of the-
so you won election, he won selection. The supporters.
Law provides, Lordship, that the
Whatever it
para
is.
7, he has copied the para 7 of his deed petition, Lordship. He has copied the provisions for appointment of Gaura, Lordship.
Preference.
Annexure 5 is there. I have enclosed it. Annexure 5, my friend is replying.
Every Gaura should be
No,
elected,
no.
Lordship.
This is clearly number A, B. Of course, they said claim of the family. Number B, wishes of the villagers, and the view of the Majudar. It is there. So there should be an election, and JHDC they have filed the affidavit. They will conduct the inquiry, and they will hold a fresh election. In the affidavit, they have already stated they are not denying they want to conduct the election. Para 7 of the affidavit.
Okay, take down.
Lordship.
The writ petitioner is before this court is sealing an order dated 25/1/2024. Where's that order?
Page 91.
Whereby the respondent number
Is respondent number 6.
25/1, yeah, 24.
Respondent number
Whereby
4.
respondent number
4.
Whereby the respondent district council has allowed the respondent number 4 to function as the Gaupura of Magur Mari area, MAGUR area, for 6 months with immediate effect from 22/1/2024 to 22/7/2024. Stop. Next, but the grievance of the petitioner as portrayed is that the election should be held. Election should be held as to who should be the Gaupura of said area. and by the action of the Respondents Council, he being an interested candidate has till date been deprived of contesting for the office. Stop. Next paragraph. The respondents 1, 2, 3 represented by Mr. S. Deb has on affidavit stated that the appointment of said respondent before is only on a temporary basis so that the village does not function without so that the village will have a headman to manage the affairs till such new finalization or election of a new Gambura. Stop. It is also stated in the affidavit that when the officers of the council had gone to the village to carry out an inquiry with regard to holding elections, the villagers obstructed the said process. However, it is stated that the authorities are ready to conduct a fresh inquiry to ascertain the wishes of the villagers with regard to the holding of the elections.
With regard to the appointment of Gambura.
With regard to appointment of Gambura, yes, for a second, correct, yes. Mr. S. A. Sheikh, Mr. S. Deb has further submitted that the inquiry going to be conducted due to the disturbances created from both sides. It is from both sides, that is on the side of the petitioner and the side of the respondent before. He prays that directions be issued to bind the petitioners from before so that a proper inquiry can be carried out. Stop. Mr. S. A. Sheikh, for respondent before, does not have any objection to the holding of the inquiry and will abide by any decision that is given by the Respondents Council. Stop. Correct? Or you'll challenge the decision also?
No, Lordship. Can I make one submission, Lordship?
Make one submission, yes.
Since my friend has, he has copied the provision for appointment of Gambura, but this is not a fresh Gambura. This vacancy arose after the date of the Gambura, Lordship. 162 of the Assam.
That is not for the court. That's for the council. Let them see.
Which is why we have appointed them.
Yes. Only my prayer is that at
Okay, temporary appointed. What right? You're right.
Yes.
Get over on on July.
Yes. Lordship, what I try to submit to your Lordship that at the time of conducting inquiry, they should take into consideration 162 of the
162.
Yes.
162.
We don't see anything.
Yes, Lordship.
Having heard the counsel for the parties, this petition, in the interest of the villagers and people of the area, is being disposed of at this stage by directing the respondent 1, 2, 3 to conduct a fresh inquiry and to ascertain the situation and as to whether, with regard to from the ground situation, and after ground situation, and to pass appropriate orders thereon for the appointment or election of new Gambura. Stop. It is further provided that in the exercise, the respondent shall conduct in any order that follows thereafter shall be as per the application of the relevant law, that is the Assam Land and Regulation
162.
with regard to the appointment of Gamburas. Stop. Next part is further provided that the respondents 1, 2, 3 shall also, before the inquiry, undertaking before the inquiry to obtain an undertaking from the petitioner and from the respondent as to the peaceful conduct.
Yes, Lordship. Peaceful conduct of the election.
No, as to peaceful conduct of the inquiry. Stop.
Yes.
I also pray, my lord, if your lordship is giving a
Time frame. As the term of the respondent to run to.
My prayer is, my lord, his term is till 22nd July, so we'll try to complete it within that time.
Yes, sir.
Till that time,
the
it should
term
not
of
be.
24 is to conclude with 22nd 7 2024. It's expected the entire exercise to be completed before the expiry of the term. Yes.
Lordship.
That term.
Much blessed, Lordship.
Close this forum. As ordered, the matter stands closed for yes.
Item number 8.
What happened? Look, Atala, settled?
No, not yet.
It's for hearing now.
Yes. Lordship, my affidavit is ready, Lordship. I'm just waiting for the signature of the official respondent, Lordship. I need only 1 week time, Lordship. I'll file it.
The matter is returned from the Lok Adalat. Stop. I don't want unresolved. Stop. Next paragraph. MSSE Sheikh and Ivasa pray for further
1 week.
2 weeks time to file if it's allowed. There's not less about 2 weeks. Yes.
All right.
Item number 9.
May I please, Your Lordship, I pray for some more time to file the affidavit for status report.
What affidavit?
For
Status
status, yes, sir, Your Lordship. We're still awaiting the status report as well as for rejoinder, Your Lordship.
I'm entering appearance on behalf of the private respondents.
All of them.
Respondent number 5 to 10.
1 second, 1 second. 13, 10 to 13, 15, 19, 21 have been served.
5 to 10, Lordship.
1 second. Yeah, up 5 to 10.
5 to 10, 11.
1 second. 5. Take down. 5 to 10.
11.
And 5 to 11. Yes.
13, 15. 13 to 15, Lordship.
5 to 11. 13 to 15.
17, 19, and 20.
Now you open okay. 17,
19 and 20.
17, 19 and 17, 19 and 20. So that leaves only 21, 18, 15, 16, 18, 21.
So far as respondent number 12, I have entered my appearance on the earlier question. Now I am entering my appearance for respondent number 16, 18 and 21.
Very good. At least only 15 then alone.
Yes,
So take like you enter, you know. Mr. S. Chanda had to enter appear on behalf of so respondents. Mr. S.E. Sheikh, who had earlier entered appear on behalf of respondent number 12, has also and is also putting in appearance for respondent number 16, 18, and 21. Stop. 15? Why 15 alone? 15 appeal also. 15 to then. As such, all respondents have been served. Yes. What? Yes, Mr. S. Chanda, you have filed affidavit?
File, Your Lordship.
Already filed?
File, Your Lordship.
Mr. S.E. Sheikh for so-and-so and Mr. S. Chanda so-and-so, Mr. Prayafon allowed. How much time? 3 weeks to file affidavit. Just that after and so-and-so. Yes.
Much obliged.
Where is the petitioner?
Lordship, petitioners are supposed to file their
Yes.
rejoinder.
Lordship, we are awaiting instructions, Lordship. Lordship, I'm praying 2 weeks time, Lordship, because
The road's already constructed now.
Lordship, they are on the verge of constructing the bridge, Lordship.
Verge of constructing the bridge.
Lordship.
Aspirate for a 2 weeks' time is allowed for a joint affidavit by the petition. Just thereafter is.
Item 11.
Make this lordship. This matter, your lordship, there is a defect in my petition. So I'm afraid I may be allowed to withdraw, but liberty may be given because there is in para 3, I make a mistake, lordship.
No, you already accepted golden handshake and resign.
That salary have not been paid to me. That pending salary is there. Actually, I should have mentioned, but while drafting, my client have not instructed where, your lordship. So that is okay. I received the golden handshake. That is, but in my petition, due to bona fide mistake, I have stated that other service benefit also.
Mr. P.T. Samma submits that due to certain defects, he may be allowed to withdraw this petition.
Yes, with the liberty.
Matters family stands.
With the liberty.
However, he prays without, he may be given liberty to file afresh if so advised.
Lordship.
This time matter stands close on withdrawal. However, liberty has played this.
Lordship.
Item 12.
Deep privilege, my lord.
Your Lordship, I pray for some more time to file the affidavit. We're
You
still
are
waiting.
appearing for respondent number 1.
Yes,
Why you think so much time for affidavit?
Because
How much time you sought?
Probably 3. Because we're sending it to Mumbai and it's on the way to Shillong. For
Where has
signature
it
and seal.
reached?
It's already with them, but they're sending it.
Yes, Dr. Mozika. Yes, MS
The
Aram
other
shut up.
respondent also.
Yes, madam.
MS Aram shut up for respondent 1 and you for and Echarnat for?
Respondent 2.
You for 1.
Yes, Your Lordship.
But you follow up for the 1 week's time
Yes.
to file affidavit. This thereafter is.
Item 13.
Please, Your Lordship. This was relating to transfer, my lord. We had sought that the place of posting may be considered on compassionate grounds. Some instructions were, my lord, sought for.
Dr. Mozika.
Well, I've received instructions, my lord. But here what happened, my lord, this lady is a compassionate appointee, my lord, otherwise also. Her husband was serving Assam Rifles and it was, he died in some accident, my lord. So to that effect, he has been compensated already.
Yes.
And now she is seeking for further compassion, my lord.
What's the prayer?
For staying the transfer. There is an interim order, my lord.
Where's the prayer?
My lord. Our prayer, my lord, was that there is a policy which says that, my lord, we can seek for one time choice posting on compassionate ground, citing hardships. These hardships were cited, my lord, and in fact, she is intending to proceed on voluntary retirement also. So therefore, my lord, she had prayed that she may not be kept in a hard station, which she had already served previously. But then she has been posted back to a hard station again.
The ground stated, my lord, the children are studying. One is studying PhD, my lord.
PhD?
My lord. The other was doing masters, my lord.
See, Mr. Pathak, I thought they were in kindergarten. PhD and masters.
No, my lord. We have already stated so in our
How will it
petition.
be a hardship?
And then
They
the
are
primary
adults.
ground,
Where? They are adults.
it is her own ill health, my lord.
Where
is the
the
primary
para
ground.
you
And
said
the
that?
Para 7, my lord. Page 6. Son Suraj Bhatt is studying MSc, Master in Science from
Well, after
Haldwani.
both the children, one's doing master's, one in PhD.
And they are not in with mother, my lord. They're staying, one is in Haldwani and other one is in Madhya Pradesh, my lord.
Mr. Pathak, I don't think we should. Have you
My
filed
lord,
affidavit?
my own medical condition is the primary ground, my lord. That we
You have been
stated,
proposed to be
otherwise,
transferred where? From?
Transferred from
our state.
Songsak, Manipur.
From?
From Mokokchung.
From Mokokchung. She's in Mokokchung now. To where?
To Songsak, Manipur. Songsak.
Seems from Nagaland to Manipur.
Basically, I don't want to go to Manipur, my lord. That cannot be.
It's in Manipur only, my lord.
What community is she?
He was already in 2017. Then now posted back. It is hard fishing, my lord. If you would look at page 21.
No, husband died in ID blast.
My lord.
You're still teaching?
She's not in teacher, she's a Hindi officer, my lord.
Still teaching, my lord.
Hindi teacher in here.
Sorry. Hindi teacher. All we are praying is that, my lord, the ground on which they have
Going back to the same place, Dr.
application is that I have
Mozika. She was transferred from this Sangshak to Mokuchung, again going back to the same place.
It is a routine transfer. What happens when the chain of transfer, my lord, is affected because
Yes, yes. Mr. Pathak, I think we'll...
all we are praying is the ground that on which they had rejected my application is that there is a policy that permits such application. They have said that they have not made it in time.
Where is that?
My lord, the application was...
See that type copied, page 30, competent authorities approved posting respect for teaching staff of your unit. Where you want to go? You want to go to Agartala?
This is the impression, my lord.
Send us somewhere else.
But the difficulty, again, you have to transfer somebody from that.
We
place,
had stated we had given a choice station, my lord, prayer in page 21. All we want is that they should consider this on merits, my lord, not by saying that we had, my lord.
Page 21.
They had basically said that I am not submitting on time.
Because you post in the Chartuwar, Kohima, Dimapur, Maram. Take down. I'm sorry, Mr. Pathak. Yes.
And
you rejected. You already rejected the application.
And what they, they say, and page 42, they say that you have.
See, Mr. Pathak, because we read the synopsis, it says he has posted so and so the pressure the only lead to after both the children as husband died in ID blast. So on that consideration also we thought that, But the children are in PhD and then studying masters.
Children are grown up, madam. They have not suppressed anything. They have not suppressed anything. Her own medical condition is such that, my lord, that station, my lord, is very remote.
But Mokuchung better health facilities than Shangshak.
But Assam Rifle has
yes, my lord.
They have their own medical facilities. Anyway, yes, this is application.
Is a very remote station.
This is an application. The petitioner by this application is assailing her transfer. A transfer order dated. Which one? Dated when? Where's the order of transfer?
Annexure 6, my lord, 1st December 2023.
Is from no.
It would be at page 28, my lord.
1st December 2023,
December
whereby she has been transferred from Mokokchung, Nagaland, from 12 Assam Rifles, Mokokchung, Nagaland to 24 Assam Rifles, Shangshak, Manipur. The ground for resisting transfer is that she is she is a widow of her husband serving is what? Anyway, she's a widow who has to look after her 2 children and for the suffering from several health complications. Stop. Her request for consideration had been rejected by order dated
14 February.
My lord,
Order dated 14 February 2024. Where's that? Annexure 10.
Annexure 10, page 41.
Problem?
They say that, my lord, it should reach well before, such a request should reach well before time. And it was actually submitted well before
Yes,
time.
her request
Cannot be a ground
was
rejection.
rejected with the reason that a request for choice of postings, if any, should reach the records branch well before the completion of the present tenure, so that the same could be examined by the Board of Officers. Stop. Next paragraph. Mr. B. Pathak submits that the only consideration that is sought is due to ill health, and that as the reason given by the respondents is that her application for change of transfer was received late, the same was considered. He therefore prays that directions be issued to the respondent to give a fresh consideration to her prayer. Stop. Now, Dr. N. Muzika, Learned Counsel for the Senior Counsel, DGSI, has submitted that the petitioner is an appointee the petitioner is an employee who was afforded compassionate employment due to the death of her husband in service and in the course of duty, and also that the reason for opposing transfer is not the reason for transfer. Before that, no. Employee who was given appointment on compassionate grounds due to the death of husband in the course of duty. Stop. He further submits that the reasons given to resist the transfer are not sustainable, in as much as the same is a condition of service, and further the children of the petitioner are already adults. Stop. Regarding the health condition of the dead petitioner, it submitted that Assam Rifles, wherever the personnel are posted, provide the said personnel with adequate medical care and attention. Stop. Next paragraph. Having heard the counsel for the parties, it is noted that the only where's your prayer in the thing before the board officers? Where's the letter? Where's the letter?
18 September 2023.
Where's the letter? You don't have the
My lord,
brief with
my
you?
letter was, my lord, in annexure. Page 21 is my application, my lord.
Oh, no, right?
Page 21, my lord, is my application, which was duly recommended and forwarded, my lord.
No, sorry. The only request made by the petitioner was that he be posted on the other units as detailed in her what is this? This is her in her application for compassionate ground posting.
Application.
Which is dated 18 September 2023. Annexure 1 of the
It's part of Annexure 1.
Yes, but it's Annexure 1 to the petition. Stop. Next paragraph. Next same paragraph. Next paragraph. Transfer being instance of service. Courts usually not interfere unless they are extenuating circumstances that call for interference. As such, this petition is no longer entertained, and the respondents are at liberty to examine the application of the writ petition afresh.
It's already been examined.
I know afresh, yes, he's going to superannuate. Matter stands close to disposal.
Not superannuated now, man. It's still has time.
She will, that's what she has some time. They are at liberty to examine.
Not examine. Is that late, man?
That's the only concession they've given with the Patak. That's it. Yes.
Voilà. Man. Definitely.
In that case, well, the stay order by specific order kind of.
Yes, this interim orders passed earlier stands vacated.
My lord, I'm praying for the 3 weeks time. Notice was issued only. Notice was issued
last week.
Last month.
Last month.
What's the matter about?
It's a pension matter, my lord. We have taken steps.
Pension matter, Mr. Guru.
I understand, my
What
lord.
is the place of these petitioners?
3 weeks time may be given. If not,
2 weeks time.
personal evidence, my lord, appearance will be sought.
No, yes. Mr. R. Guru prays for not further 2 weeks time to obtain instructions. They expected the next day the instruction will be on board. Just understand what is the problem then?
Exactly.
If we can dispose of by
understand.
directing, that's all. Why put these people to pensioner coming to court? He has to pay the lawyers also.
Correct, my lord. Absolutely.
Yes. Unless Mr. Sona is doing pro bono.
Degree of license.
Yes.
I was paying for respondent 4 to 7 million.
Meet please, Your Lordship.
Yes.
Lord, we have taken steps on RBI and Lord, this matter was fixed for consideration of our interim prayer. Lord, basic grievance was, Lord, that the bank has relied upon the circular of the RBI, Lord, which has been stayed by Your Lordships. But their entire case is based on that. Now that having been stayed, Lord, the petitioner has a right to continue, Lord. And Lord, there is other prayer, Lord, even the cooperative departments have also been served with the notice, Lords. And we have also alleged that the tenure of the
One second, Mr. Dubey. Are all the parties up on board now?
Yes, my lord.
Oh, state, okay, fine.
Only but,
now everyone's appeared.
I'm 4 to 7, my lord.
1, 2, 3, you have Mr. Shulai.
Yes.
Joao Gautam, I'm 4 to 7.
I'm a prima.
You are there, Dr. Mozika.
8, 9,
Reserve Bank 8, 9?
8, 9, 10 also.
8, 9, 10?
Well, steps have been taken upon RBI, my lord.
The interim order continue. When are you going to file affidavit?
We'll file with 2 weeks time.
What about you are paying for whom, Mr. Sumer?
He's with me.
Acha. Then MSR only 1, 2, 3 with Mr. Shulai. Yes.
Well, the interim order is passed in the other case, my lord, where the notification was stayed. In this case, there is no interim order.
Offence is here.
There is the part interim order is there, my lord. My senior friend would kindly have a look. But so far as stay of further appointment.
So only to that extent. We'll file an affidavit, my lord. The entire matter can be heard.
Lord, already, Lord, considerable time has been granted to Lord respondents. Let Lord, Your Lordship, this is the last opportunity. If they fail to file, Lord, Your Lordship would consider the interim prayer, Lord.
Only thing Your Lordship is done. He was the signatory to the decision taken, Your Lordship. Whether he can challenge that, Your Lordship.
That will come by affidavit. We can't just on your submission, dismiss the petition, eliminate.
My lord, second aspect, my lord, he is also backdoor employee, backdoor entrant.
Oh.
There was no regular selection process, advertisement, anything, my lord. Whether he has any right to continue the program. And thirdly, my lord, what is the effect of staying of an order, my lord? It is not completely wiped out. It's only at least for the time being.
Lord, they have still not
of
filed any
RBI.
affidavit. Lord, if they can argue, Lord, definitely I can.
But where in the other high courts has been stayed?
No, that is with regard to
Only
clause
the
4, clause 4, Your Lordship.
Only the
of that
clause has been
notification.
stated, my lord. But that, in my humble submission, will not automatically entail his reinstatement, my lord. Because the purport of a stay order and washing of an order are different.
Of course. Anyway,
We'll file an affidavit, my lord, in 2 weeks' time.
My Lord, if my learned friend sees, my Lord, that even assuming that has to be done with the prior approval of RBI, my Lord, and RBI has clearly not given, so therefore the termination has not been given effect to. Lord, let them file an affidavit, I respond to it, my Lord.
Yes.
And Lord,
Dr. N. Mozika on behalf of response 427, assisted by so 427, and Ms. Inishulai for 123. Pray for further 2 weeks' time for affidavit. Yes.
I'm for respondent number 11, my Lord.
You're for?
Respondent number 11, my Lord.
Oh, you're filing affidavit? No.
Yes, my Lord. Yes, my Lord.
And Mr. Jeshalla for number 11, pray for a further 2 weeks' time file affidavit. Stop. Petitioner to obtain status of service upon the other respondents, that is Reserve Bank number 8, 9, and 10. These are 2 weeks.
8, 9, 10.
Yes, interim order passed earlier shall continue till next date.
deeply obliged.
File it. Just interesting matter. Yes.
What are the respondents are to file the affidavit now? I pray for some more time, Lordship, to instructions.
When are you going to file affidavit then? What's the matter about?
Is the matter pertains to, yes, my lord, outstanding bills.
The bills outstanding, or you admit them or you don't admit them?
Lordship, I'm still yet to receive the
Mr. Ikawalang, response allowed for that. How much time?
Lordship, another 3 weeks, Lordship.
You get, see, the thing, these are matters regarding contractual bills. If you come to instructions that the bills are disputed, then you won't need to file an affidavit also. But if you want to file an affidavit, that means it will necessarily take longer time.
Lordship, I have yet to receive instructions, Lordship.
Within please allowed further 1 week's time to obtain instructions. Yes.
17. 17.
Lordship, I have taken steps upon the respondent 1 and 2.
Appearance on behalf of respondent number 2.
Lordship, I'm making appearance for respondent number 1.
Number?
1 and 2.
No, sorry. How many respondents are there?
1 and 2, Lordship. 2 respondents.
You're for 1?
Yes, Your Lordship.
And you're for 2? What miscase is there?
This is for a modification.
Okay,
Vacating the stay, Lordship. For vacating the interim order.
Who has filed it?
Your Lordship.
Respondent 1.
You moving it today?
Your Lordship. Sine is on legs, Your Lordship.
Lordship, allow me 1 week's time. I'll file my response.
2263 will operate. To what?
Lordship, what happened in this case? In the application for modification, now they have taken an allegation against the respondent number 2, saying that they don't have any authority.
MS Biswakarma, Hazard Page number 1, and Mr. Inombri on behalf of number 2. Such service complete. Stop. This is matter after 2 weeks. Stop. Miss case number 83. Miss 83 2024. There's an application for vacating, modifying the order dated 2/5/2024. Pass interim order dated so 2/5/2024 by the respondent number 1 applicant. Stop. Stop. Mr. M.L. Nongpur, counsel for the petitioner of the party, prays for 1 week's time to file objection to the same.
Lordship.
Yes. List after 1 week or 2 weeks?
2 weeks, Lordship.
List after 2 weeks. Stop. Along with the main case for consideration of. List after 2 weeks, the main case is.
Lordship, the interim order may be continued, Lordship.
Interim order shall continue next year. You're supporting him?
They are the committee, Your Lordship.
Hearing, item 21.
Kami le namar mga laong katu katay murti na dale pingan suan ulam dale apa tu ka hearing video.
May it please your lordship. In this case, your lordship,
Yes. You see the last order?
Lordship, yes.
You see the last order, Mr. Jha? The last order of the school.
My lord, that's with regards to the compensation. my
I
lord.
don't know, your lordship, whether
Compensation?
last time I...
This is the case on OBC.
Yes, my
lordship,
lord.
yes. She has no... There's no lordship. There is. I hear your lordship. This is the case, lordship. Last time I made a submission that if relief is declined, then compensation, your lordship. But in this case, which I'm placing before your lordship right now, I don't think it will help the petitioner, your lordship. Because in this case, your lordship, what happened? The Honorable High Court of Madhya Pradesh, in a writ petition filed by the petitioner therein, your lordship, in spite of the fact that the Honorable High Court came to a finding that the denial of appointment is not justified. Refused to pass that direction and dismissed the writ petition. Then it went up to Supreme Court. Then Supreme Court directed that she should be given the appointment plus a compensation of 10 lakhs. So it may not.
Where's judgment?
My lord, here the the petitioner case is that, my lord.
No, that we know petitioner's
My
case
lord,
very
my
well.
lord.
Now it's been enough. Like we've heard
So
it
it may
last
not
time.
help, your lordship. Because in this case, your lordship,
See, the only thing, the baseline of the entire case is just that there's no OBC category in Meghalaya.
Yes.
And so the appointment of the petitioner being against an OBC vacancy
because
could not have been made in the normal course of business. What happens, suppose OBC is not here, where does that post go?
Lordship, that is what.
My lord, even this is not only relating to Assam Rifle, my lord. This is also with regards to the BSF or other paramilitary forces, my lord. So definitely, my lord, it is the union that has to produce where the others appointed or not, my lord. And SCC.
So suppose in such cases, Dr. Mozika, you've selected a person, right, based on like from the OBC quota, okay. Now when she's asked to produce, she produced certificate, but it's not from the state of Meghalaya. OBC quota fixed for state of Meghalaya. They have ST from so and so, so many ST from the state, so many SC from the state. Now appointed by the authority under OBC quota of Meghalaya, but on Meghalaya there's no OBC. So what happens to that post?
But I have restriction, my lord. Please refer.
That post just evaporates. Because now she won't be appointed to that post. What happens to that post then?
But what it says, my lord, the instruction which I have received, that SC has 1% reservation in Meghalaya, my lord. ST is 44% and OBC 5%. And it says, my lord, 2 notified vacancies were there. One has been filled up and one is still vacant.
OBC?
OBC.
That means filled up by whom? There was no OBC category.
I think this is the candidate which was filled up.
So what happens? Suppose no one's appointments, you don't give appointment to her because she can't produce OBC certificate. What happens to that post then? It's carried over.
It's carried over. It says.
Carried over then to what end? Because OBC is not there in Meghalaya.
Never to be filled up. It will never be filled up.
Or it goes to another state.
It doesn't go to another state.
That means people are being deprived of employment. If there are posts that are there, people should be employed. What's the court to do in such cases then?
The state should come out after 342 amendment. The state can come out with a list. At least that will help in filling of the.
You think the state will go into such an exercise? They can't even decide on the basic things. So, Mr. Shulai, as Additional Advocate generally advise the state to bring about notification under Article 342. Which judgment, after which amendment was that?
105.
That's 105th Amendment of the Constitution. Because this case can't be helped, Mr. Jha, what to do?
It is in the larger, my lord. It is not for the one department, my lord. It is the entire.
18th Amendment. 18th Amendment. We understand, but I think that we understand the predicament that he is in also.
My lord.
A person has been legitimately selected and under a certain quota, then.
And even, my lord.
Actually, when the seats are reserved, my lord, I think in every parliamentary vote there will be some provision.
There will be provision. It's like suppose in Meghalaya we don't have provision for, in Assam they have ST plains and ST hills. Scheduled tribe hills, scheduled plains. Now in Meghalaya we don't have scheduled tribe plains. It's like, a post being created for scheduled tribe plains in Meghalaya, and then there's no scheduled tribe plains. What happens to that post?
My lord, even further, my lord, the SCC, Staff Selection Commission, my lord, who has advertised the posts, my lord, that should be aware that the OBC does not prevail in Meghalaya, my lord.
Then you file a suit of damages.
My lord, that will take long. My lord, admittedly the retirement date is 2057, my lord.
It's very unfortunate. See, when a person comes to court has help, but then no matter what, you kept this matter lingering, we've kept on asking for banging, you've been banging on every door. What do you want to show this judgment, Mr. Shulai?
Lordship will not help your Lordship because in this.
It will not help who? Him or you?
Look. Because in that case, your Lordship, what happened there, as I have submitted, your Lordship, the Honorable High Court of Madhya Pradesh refused to give appointment to the petitioner in spite of the fact that it holds that the denial was not sustainable. So, your Lordship, the division bench also dismissed, and then it went up to Supreme Court, came to a finding that she has been illegally deprived of her appointment, and that as she was, the government was directed to appoint her, plus a compensation of 10 lakh has been awarded. So that is the case here is.
No, 10 lakhs recovered from the officers who denied her. This is a personal kind of damage. Now, what would you do, Mr. Jha?
My lord, definitely, my lord, it is the illegality has been.
No illegality.
My lord, once.
No illegality both can be irregular.
Irregular, my lord. After
illegality means your appointment was illegal.
My appointment, 2 years they took, my lord, for the examination of the everything, my lord, the documents and everything. After 2 years, when I applied.
But can we read into something which is not there? There's no OBC. Can we just read by the court? Can it read down that the fact there's no OBC category in Meghalaya to direct them to give you appointment? No. We can read on a provision of law to facilitate something which to make it, workable. We can't read down or read into,
My lord, that's but bona fide expectation is also there, no, my lord.
That is long gone. That's when he first came to court.
Yeah.
The legitimate experience bonnet is gone. Now we are just in what we will dispose of. Close writ petition. We can't direct the government to enact the legislation or to, to issue.
It's a matter of policy for government also.
It's a matter of policy. We can't do that. We can't examine also. It's up to the wisdom of Mr. Shulai and the government.
I think that government I cannot because that's why it is a fight between the Union of India, my lord. So whether the OBC or what is the mark sheet marks which has been obtained by the petitioner, my
Whether
lord.
comparable
Whether it can
journalists-
be treated as a general also, my lord. Those, how many posts were there, my lord? How many?
Exercise, my lord, I think general post must have filled up.
They'll be filled up. Whether that post can be converted
This is a
into no. See, only one thing: if the post is it possible? Is there any instance where the post can be converted into, just because of the case, it can convert it into a general post?
Then the question will come whether she is there in the general merit list or not. Because if that is done, the next in the list, my lord, he'll have a better right there.
Yeah, there was a similar case which is handled by this court maybe a year ago. Very interesting. I mean, your case only, 3-4 of them. This case is a open-ended and dead-end case also. You tell your client that this is a position, but it goes on the next date. No relief. You can understand the frustration after getting selected into a parliamentary force. Yes, Mr. Shulai, Andy Shulai today has produced an authority. No, forget it. Mr. Shulai has expressed inability to present authorities connected with the matter. Only it is a matter after 1 week we'll dispose it out for final disposal.
Item 23.
May I please, Your Lordship? Your Lordship, on the last occasion it was heard, but respondent number 6.
My Lord, may kindly have order dated 17 April
Yes.
2024. My Lord, some direction will pass by this honorable court with regard to the private respondent, because my Lord, when the matter was heard on that day,
So your response number 7. You've served him.
committee is required in this case.
Lordship,
Yes.
Your Lordship, we have taken the first step, Lordship, and it was.
You have ensured service. Why? Who appeared at the time? Where's Mr. Hassan? I saw him just. Why are you hiding behind? You give assurance. See the order is 17/4/24.
They have not given a copy to us, my
Why
Lordship,
not give a copy?
We have served to the petitioner, and it is already duly served, Your
We're
Lordship.
waiting for them so that we can take this step.
You informed them. When was it served? Where? Where's the proof of service?
Your Lordship, the original receipt copy is with the petitioner, it's himself. But he have sent me through WhatsApp. It's here also.
Petitioner has given through Dusty, my Lord.
Yes,
See.
Well, then you informed the petitioner. Yes. The writ petition, the council petition has produced a notice that this is Nazima Begum, number 7.
Nazibur Rahman, my Lord, sorry.
Hmm?
On magazine committee.
But it should be
Nazibur
managing committee, respondent number
Nazibur
6.
Rahman.
My Lord.
Then this is receive the copy from the petitioner on today 29 April at 10 a.m. ex officio member convener. Just see this. Just show it to Mr. Hassan.
He is the respondent number 7, my client. He is the respondent. My client is the.
He received it again.
Yes, ma'am.
Not for number 6. For number 6.
For number 6.
My Lord,
Okay.
yes, he received to hand it over to respondent number 6 of school
Okay.
managing committee.
How old is Mr. Coach, counsel for the petitioner, has produced a notice indicating personal service on behalf of the respondent number 6, Mr. S.K. Hassan. Please allow some time to ascertain the said service. We will list the matter after 1 week. Yeah.
Highly
2 weeks.
24.
Here, my lord.
Why?
I'm a bit handicapped today, Lordship. I mistakenly left my brief at home, Lordship. Just for your Lordship,
That's a valid excuse. That's an honest excuse, yes. Which is sometimes prays for some accommodation due to personal difficulty. This is a matter of 1 week, yes.
Mile.
Hello.
25
connected, Your Lordship.
Mile, two matters are connected.
25 connected, Your
Mile.
Lordship.
26.
Deeply obliged.
This is a petition, my lord, under section 24, read with rule 1B of the AD rules. For
Yes,
transfer of
Mr. Salam, what's the problem? On his way where? To Ghati or to the court? Could not wait for the any urgency.
There's an interim order of status quo, but the problem is they are not, despite the injunction from the trial court and the status quo from this court, they are still violating it. But I cannot file a contempt in this proceeding. That's why, my lord, we're praying that if we could be transferred, then we
Transferred to?
What has happened is we were supposed to file it. The suit, the cause of action arose from the European ward of Shillong. Inadvertently, it was addressed to the additional deputy commissioner, assistant to deputy commissioner under the AD rules, but it should have gone to the Munsif, my lord.
Yes.
So that is the issue here. So
You filed a suit in the wrong jurisdiction.
Yes, and injunction order was passed in my favor.
But then court or jurisdiction is not est.
Yes.
Quorum
So,
non
but
juris.
Under section 24(5), read with one.
So what do you want now?
We want the suit to be transferred to the court of the Munsif, my lord. That's all. And the matter may be decided on merit.
Is rejected from there? You won't file in a court of correct jurisdiction.
Our difficulty is that, my lord, we don't. The injunction order is already passed in my favor.
Doesn't matter.
So it may be transferred. No prejudice will be caused to either side, my lord.
Yes.
Because
2 weeks.
Order
1 week.
39
Okay.
rule application is still pending.
Yes.
So interim order may be
It's interim.
extended until further
Yes.
orders.
This is a matter after 1 week. Yes. So interim orders pass earlier shall continue. Parties pray for them that the matter is after 1 week. Yes. Respond number. Number 1 is.
27.
Interim order may be continued.
Yes.
Obliged.
Lordship, I kindly pray that this matter may be passed over for a day, Your Lordship.
Why?
Mr. Nongri is having personal difficulty, Your Lordship.
He was here just now.
Yes,
He
Your
didn't look any way personally, inconvenience in any manner.
Kindly have it on Tuesday, Your Lordship.
I think he wants you to argue it. Correct?
Right.
Let me know. Yes, Mr. Pasanthi prays for accommodation. This is a matter after 1 week, yes. You will argue it next time? Yes.
I have to seek for instruction of my senior, Your Lordship.
33.
Yes.
May I please, Your Lordship, this matter is for hearing, my lord.
Of course,
order
yes.
challenge passed by the Lokaita, Honorable Lokaita, my lord. So, here, my lord, the Honorable Lokaita has exceeded the power, my lord. As per section 20, clause 1, we have filed a complaint.
1 second.
Yes, ma'am.
It is there. Yes, what's the problem, Mr. Sheikh?
Not Mr. Lordship here, private respondent Lordship.
Yes.
Private respondent number 3 and 4 Lordship. So I'm just entering my appearance Lordship because they received the notice late.
Is that correct, Mr. Hassan?
No, my lord. Ex parte order was on 16/4/2024.
Then?
I'll take necessary step Lordship.
Ex parte?
No,
And if you
ex parte,
find out
my
of certain side?
Despite of giving enough opportunity.
Jindal.
My lord, in fact, matter can be disposed today itself. Very,
My lord, yes, my lord.
Very
With
short
a limited
matter.
prayer, my lord.
Yes.
With a very limited prayer, my lord. My lord, may I please, my lord?
1 second. Where's the order of ex parte?
My lord, on 16/4/2024, my lord.
Yes.
Prior to this, 2 order was there, my lord, giving opportunity.
3, 4, and 5. That means.
3 and 4 no, sir.
What about 5?
5 is block development officer on his personal capacity, my lord.
Yes. Yes.
My lord. As per Section 20 of Meghalaya Lokayuta Act 2014, Section 20 Clause 1 is for filing of the complaint petition.
Where is that?
My lord, have Lokayuta Act, my lord, Meghalaya Lokayuta Act, my lord. (2014) Meghalaya Lokayuta Act.
Okay.
Yes, my lord. May I please, lordship, on Section 20, my lord. Section 20, subclause 1.
Procedure.
Yes, my lord. Chapter is 7, procedure in respect of preliminary inquiry and investigation.
Yes.
I have filed a complaint petition under Section 20 before the Honorable Lokayuta. Thereafter, my lord, the Honorable Lokayuta under Section 20 Clause 1, may I read, my lord?
Yes.
The Lokayuta shall, on receipt of a complaint, first decide whether to proceed in the matter or close the same. And if the Lokayuta decides to proceed further, it shall order the preliminary inquiry against any public servant by its inquiry wing or any agency. So, which means Lokayuta first has to satisfy, then he has to proceed. In my case, Lokayuta satisfied themselves and proceed for preliminary inquiry. Accordingly, preliminary inquiry was...
Now what happened? You filed a complaint.
Complaint, my lord.
Then
under
the preliminary inquiry was done.
Preliminary inquiry was ordered and accordingly inquiry was conducted. And as per Section 2, subclause 2, inquiry report was filed before the Honorable Lokayuta.
Right.
After receiving the inquiry report, my lord, preliminary inquiry, my lord, subsection 3, my lord, subsection 3. A bench consisting of not less than 3 members of the Lokayuta shall consider every report received under subsection 2 from the inquiry wing or any agency, and after giving an opportunity of being heard to the public servant, decide as to whether there exists a prima facie case and make recommendation to proceed with one or more of the following actions, namely, the Lokayuta, after receiving this, has to give an opportunity to the public servant, my lord. After that, if Lokayuta finds, if there exists a prima facie case in the preliminary inquiry report, then Lokayuta has no option, or only there is 3 options, my lord. Subclause A, investigation by any agency.
Yes.
Subclause B, initiation of departmental proceeding or any other appropriate action against the concerned public servant by the competent authority. Subclause C, closure of the proceeding against the public servant. In my case, in the impugn order, my lord, none of the thing has done, my lord. Only the order has, my lord, if we see the impugn order, the case is closed.
No, preliminary inquiry was done. Now you say that the officer was called.
Officer, they have given, in the Lokayuta, they have filed their affidavit. Opportunity was given to the private respondents, to the petitioner as well, my lord. After filing their affidavits and after hearing the matter, the Honorable Lokayuta has pleased to pass the...
You see, you read the section.
Yes, my lord.
See, a bench consisting of less than 3 members of Lokayuta
Yes, my lord.
shall consider every report received in subsection 2, that's
Yes,
preliminary inquiry,
Yes, my lord.
from inquiry wing or any agency, and after giving an opportunity of being heard to a public servant,
Yes, my lord.
decide as to whether there exists a prima facie case.
Prima facie case.
They have to decide that.
They have to decide.
And if there is, and make recommendation.
Make recommendation, 3 options, my lord.
Yes. No,
One,
if there is a prima facie case, then make recommendation.
Yes, my lord.
Yes.
That is my case, my lord. In the impugn order, my lord, in the impugn order, may I, in the writ petition, my lord, page 52, my lord, page 52. Why the Honorable Lokayuta has exceeded the power, my lord?
352.
No, my lord, 52, annexure 5, my lord. My lord, have my lord?
Yes.
May I read, my lord?
Yes.
Yes, my lord. I'll read the operative portion, my lord.
Read the whole order, very short.
Yes, short order, my lord. Peruse the preliminary report. Most of the works have been completed as per the preliminary report. However, following works are yet to start, but the wages amount have been credited to the bank accounts of the job card holders. That is crucial part, my lord.
Yes.
1, 2, and 3, these are the construction of the project which have not completed. But money has been disbursed, my lord. Hence, I am satisfied that there is no prima facie case of corruption against the public servant as per the preliminary report, and the case is disposed of as following.
Yes.
Now, under this, my lord, number 1, the Community and Rural Development Department shall cause an inquiry regarding payment of wages to the job card holders, when the work order have not been started as mentioned in the preliminary report, and take action accordingly. Number 2, proceeding is hereby closed. This is where the Honorable Lokayuta has exceeded the power, my lord.
Why?
The one hand, they have said the Honorable Lokayuta is not satisfied. There is no prima facie case. If there is
Here
no
I am satisfied, there is no prima facie case.
Yes, my lord.
Yes.
Then one hand, his Honorable Lokayuta is saying there is no prima facie case, and I am satisfied. On the other hand, in the next portion, the Honorable Lokayuta has directed the Community and CNRD to conduct an inquiry and take action accordingly. Meaning, I am failed to understand, my lord. So now second part is what constitute corruption, my lord.
Yes.
So this amounts to a corruption, my lord. Work has not even started. Money has been disbursed by the respondents, my lord. BDO, Block Development Officer, in hand in glove with the BDO.
Complaint?
My lord, yes, my lord.
Let's see your complaint. Let's go to your complaint.
My lord, yes, my lord. My lord, here, my lord, I have not annexed the complaint, my lord.
Why?
In the writ petition. But only have challenged the inquiry report, my lord.
You have to the basis of your complaint, whether your complaint is against specifically against these private respondents for defalcation of funds.
No, my lord, our complaint is to find there is a misappropriation. Work has been not done.
Exactly. Now there's been found there's no misappropriation. Only that the works are complete, but money been paid to the people it should go to. So on the part of those people you seek allegation, they have not been seen to have taken any illegal gratification.
My lord, may I?
Where's the complaint? Let's see your complaint.
My lord,
you don't have it in your file?
No, I don't have with because my lord, the complaint, in the Lokayuta, I'm not the person who is handling the case. Mr. A.S. Hazarika is the person.
That is not a concern of the court.
I don't have
what
right now.
Materials?
Yes, my lord, I don't have the complaint copy right now, my lord.
Then?
My lord.
Mr. General, what's the complaint? You have a copy of the complaint?
I'm afraid I don't, my lord. I don't.
My lord, case record may be called, my lord.
On the basis on which inquiry was done, whether...
May I pray, my lord, in that circumstances, my lord, case record from the Lokayuta may be called for, my lord.
Not necessary. Only the complaint, only the copy of the complaint, my lord.
Yes, my lord.
Get it from Mr. Hazarika.
It's in the lordship that if my lord peruse the preliminary report, each and every allegation
yes, my lord.
quoted their lordship. And
where's the report?
Findings also recorded.
My lord, preliminary report, my lord. Annexure, my lord.
31.
My lord, yes, my lord. Annexure 3, starting from Annexure 3, 27 page. And the findings, my lord. Findings from, my lord, 34, 35, my lord.
Okay.
This is the preliminary report, inquiry conducted by the concerned officer, my lord.
Yes.
My lord, page 35, may I take you? The last finding, my lord. The last. May I read, my lord?
Yes.
During inquiry, some materials like stones and sand have been found at the site of the project. However, actual construction is yet to be started, but the bills of the wages already drawn. In this regard, President of the Secretary stated that site preparation is already done by the job card beneficiaries, and wages money is directly credited to the beneficiary account. The bills for the material have been drawn by the VEC functionaries.
Have not been withdrawn.
Yes, ma'am, withdrawn by the VEC functionaries. The statement of the VEC President is enclosed herewith and marked as Annexure C, my lord. Now, my lord, there is some anomalies also, my lord, with regard to the, my lord, ring well, my lord, construction of the ring well. The person's name reflected in the database, but in fact, it is given to the other person. My lord, at page 37, my lord, at page 37 of the inquiry report, my lord, may I take the findings, my lord? Number 4, in Roman, number 4.
Yes.
Sorry, my lord. Yes. For construction of the elevated water tank at Kasharipara, sanction amount so and so thousand, only white work order dated 18/11/2019. Findings, my lord. The construction of elevated water tank number 1, no work order dated so and so registered in JC number so and so as per work order total number of household 11. However, the project is constructed at land of Sri so and so for the convenience of the 10 household. The project is completed, but bills of wages and material have been drawn. Payment details of the project is marked as annexure so and so. Now come to 5, my lord. The finding part, my lord.
Yes.
The construction of elevated water tank number 1, white number, order dated so and so. The total number of household number 4, construction of the project was decided at the resident of so and so, job cut number so and so for 4 household. However, actual construction has not started, but wages money is already credited to the concerned job cut beneficiaries. Material bills have not been submitted for nor drawn by the VEC functionaries. My lord, without construction of the work, my lord, in the Lokayata, the impugn order, the Honorable Lokayata has mentioned, has reflected, without construction of any work, on what basis the amount has released, my lord. And as of now, we don't know whether the material bill has released or not. My lord, the block officials and hand in glove with the VEC functionaries had done all these things, my lord. And if we see the impugn order, my lord, impugn order is in violation of the act, my lord. My lord, the Honorable Lokayata cannot, my lord. On one hand, they cannot say that I'm satisfied, there is no prima facie case. On the other hand, the Honorable Lokayata then cannot direct the CNRD to initiate action against the block officials. Meaning thereby, if he direct the block officials to initiate action, meaning thereby there is a prima facie case, my lord. Otherwise, why Honorable Lokayata has directed the block officials? If there is no prima facie case, no element of corruption. My lord, this is an open and shut case, my lord. He's violating the provision of section 20, my lord.
Open and shut case?
My lord, yes, my lord. As per my humble understanding, my lord. Violation of section 20, my lord.
Yes, Mr. General.
May please, Lordship. It's not an open and shut case. There are 2 objections. I'll be very brief, my lord. There are 2 objections I have against the writ petition filed. Number 1.
Yes.
Number 1, my lord, may kindly look at the impugned order.
Yes.
I am certain Lordship would have noticed that the impugned order, my lord, is in 2 parts.
Yes.
There are 2 effective operative parts. One part is the finding of the Lokayukta that there is no prima facie case made out.
Yes.
First part. Second part is the direction to the CRD department for conducting some inquiry, etc.
Yes.
So it's in 2 parts. Now, the first question that Lordship will have to address Lordship's mind on is the locus of the petitioner.
Who's he?
To challenge either of the parts. So as far as the first part is concerned, where his complaint has been found to be or has been closed on the finding that there is no prima facie case,
yes.
Very well. It may be that he has the locus to challenge the first part. The second part, where, without going into the act for the moment, the second part where Lokayukta has directed for inquiry to be conducted, etc., against certain persons being my friend appearing for the private respondent. He is not a person aggrieved as far as the second part of the order is concerned.
Yes.
How is he aggrieved by that second part? If anybody should have been aggrieved, it is the private respondent. Private respondent is sitting quietly. He hasn't challenged that second part.
Yes.
So the second part, my lord, cannot be challenged by the petitioner in this case, in this present case. I would in fact say that the petitioner should be glad that in spite of his complaint being closed,
in spite of there being a prima facie case,
in spite of that, he is getting something. Some sort of inquiry is to be conducted, and this inquiry, my lord, just to humbly point out, it is under the. I've mentioned this in my affidavit. It is under the Manrega scheme, there is provision for conduct of inquiry. So, therefore, I will not open this.
It's okay.
So, under the Manrega scheme, my lord, there is section 25 is there, 23 is also there. There are certain provisions which provide for inquiry, which provide for imposition of fine, penalty, etc. So, to give some benefit or some relief to the petitioner, maybe this direction was passed. Petitioner cannot challenge the direction. He is not a person aggrieved as far as that second part, the directions are concerned. So, first objection, small objection, short objection, but an important objection, my lord, is the locus of the petitioner to challenge the second part of the impugn order. Now, the first part is left, my lord.
Yes.
The finding that there is no prima facie case. Now, as far as the second part is concerned, I immediately go to my second objection. My second objection, my lord, backed up by the law in this respect, is that the petition, so far as it challenges the prima facie finding is not maintainable. The writ petition which has been filed under 226, so far as it challenges the finding of fact conducted by the Lokayukta, the finding of fact leading to the conclusion that there is no prima facie case, that finding, my lord, and I will place the law, the finding is not justiciable.
Yes.
And that a writ petition under 226 seeking certiorari is not maintainable. If Lordship allows,
yes,
there is a judgment passed last year by the Supreme Court. This is 2023 SCC Online by the Honorable Chief Justice. I'll spend about 5-6 minutes. There are some important paragraphs in this, my lord. They have referred to a lot of previous judgments. I'll start with the second page, para 51, my lord. The first, I'll read, my lord. The first cardinal principle of law that governs the exercise of extraordinary jurisdiction under Article 226 of the Constitution, more particularly when it comes to the issue for writ of certiorari, is that in granting such a writ, the High Court does not exercise the powers of appellate tribunal. It does not review or reweigh the evidence upon which the determination of the inferior tribunal purports to be based. It demolishes the order which it considers to be without jurisdiction or palpably erroneous, but does not substitute its own views for those of the inferior tribunal. The writ of certiorari can be issued if an error of law is apparent on the face of the record. A writ of certiorari, being a high prerogative writ, should not be issued on mere asking. First thing that comes out is that writ jurisdiction cannot be converted to appellate jurisdiction, and in fact that is what is happening here. I'll just elaborate on this in a moment, my lord. If I can request my lord to look at para 54. Next page, my lord. Para 54. Relying on so-and-so, the Constitution bench of this court in the case of Hari Vishnu Kamath laid down the following propositions as well established. 1 is there, 2 is there, I'll go to 3, my lord. The court issuing a writ of certiorari acts an exercise of a supervisory and not appellate jurisdiction. One consequence of this is that the court will not review findings of fact reached by the inferior court or tribunal, even if they be erroneous. And this is from a constitutional bench, my lord.
Yes.
Para 55, my lord. This court explained that a court which has jurisdiction over a subject matter has jurisdiction to decide wrong as well as right. And when the legislature, my lord, this is important, when the legislature does not choose to confer a right of appeal against that decision, it would be defeating its purpose and policy if a superior court were to rehear the case on the evidence and substitute its own finding in certiorari. So, my lord, there are other paragraphs, but I'm quietly confident I need not spend too much time on this aspect. Under the Lokayukta Act, the Act is in front of my lord, there is no provision of appeal.
Yes.
So, if there is a finding under section 20, subsection 3, I think.
Yes.
That finding, there is no provision of appeal that has been provided against that finding. Now, if there is no provision of appeal against that finding, by filing an appeal in the guise of a writ petition, that absence cannot be sought to be made up, my lord. So if there is no finding, if there is no provision of appeal, by filing a writ petition, then taking, my lord, through the inquiry report, the factual aspects of the entire thing, my lord, and to expect this honorable court to substitute its own finding on fact, my lord, that is not, cannot be permitted, my lord. That will be circumventing the intention or the wish of the legislature, and that is what this constitutional bench judgment is saying, my lord. So, my lord, that being the position, I had filed a show cause, an affidavit, but I had not touched the factual aspects of it. Because the position of law is very clear, the position of law being that if there is no provision of appeal provided, you cannot file an appeal in the guise of a writ petition, my lord. In fact, the Supreme Court has gone so far as to say that even if the finding of the lower tribunal is erroneous, it cannot be interfered.
On facts.
On facts, my lord. So the Lordship would have noticed the entire attempt on the part of the petitioner was to convince this honorable court on facts, that factually Lokayukta was wrong in coming to the conclusion that there is no prima facie case. So I need not, I'm again confident, I need not speak anything on the factual aspect of the matter. Just a last submission, a small submission, that if my friend is unhappy with the second portion of the order, we are prepared for this honorable court to strike out the second portion. It is actually for his benefit. It works, it operates for his benefit. But if he is challenging that second portion, saying I have no jurisdiction to pass that second portion, Lordship may strike it down. We are okay with that. As long as the first portion, the finding on prima facie, there not being any prima facie case, as long as that is upheld, and that should be upheld, I place this with all respect at my disposal, Honorable Court under 2 to 6 exercising certiorari cannot or is not really in a position to interfere with that factual finding, my lord.
Yes.
That's
yes,
all.
Reply.
My lord, my learned senior is very correct with regard to the judgment. This court is act as an appellate jurisdiction, appellate tribunal. My lord, we are not seeking of the go into the merits of the matter.
No,
it's a matter, my lord, prima facie. Yes, my lord.
Like on, like, if it's palpably illegal.
Yes, my lord.
Number one.
Number
now, that is very important, and like with that is one thing, because jurisdiction in such matters.
Yes, my lord.
You have to have relief. Doesn't mean that when something grossly illegal happens, that because of appeal you can't come. Of course you can come, but you have to satisfy the court that it is such an act which requires interference or intervention or correction.
My lord, yes, my lord. My lord.
Now, how do you say that this finding of the Lokayukta needs correction from the court?
My lord, yes, my lord. It needs correction, my lord.
Under 2 to 6.
My lord, yes, my lord. My lord, the impugn order itself, my lord, it's against the said act, my lord.
The act.
Yes, my lord. The act itself under section 20 clause 3, it says, my lord, 3 options, my lord. If they arrived at a conclusion that there is a prima facie case, they can proceed with 3 options. Then, my lord, in the second part, with regard to the second part, if there is no prima facie case, one hand, Honorable Lokayukta has said.
So you mean to say that the order is contradictory?
Yes, my lord, contradictory. That is one
no
part.
prima facie case, at least I'm asking for inquiry.
Yes, my lord. If there is no prima facie case, invoking section 20 clause 3
but then
subclause C.
He has said that that is under the MNGRS Act also that's provided.
My lord, that is correct, my lord. That we are not going to that. We are before the, my lord, special body. We are before the special body under the special act to file a complaint and with regard to the allegation of corruption, my lord. Release of money without constructing the work, my lord. So the special body has the power, my lord, under section. We are not going into the Manrega Act, my lord. Of course, in Manrega Act, BDO has the power, Deputy Commissioner has the power to issue inquiry and all this, my lord. Job card has their rights, safeguards their rights. My lord, with regard to the second portion, my lord, if there is no prima facie case, then Honorable Lokayukta would have applied section 20 clause 3 subclause C, invoking that the complaint can be closed, my lord.
Yes.
My lord, I am aggrieved because there is in the impugn order itself, the Honorable Lokayukta has reflected that three projects are there which have not completed, my lord. Now comes to the another aspect, my lord. What constitutes corruption, my lord? Corruption means, my lord, anything which is contrary to law, my lord, contrary to rules, regulations, or any some taking gratification, my lord. The construction work has not been completed, money has been disbursed, my lord. Then what amounts to corruption? I am putting myself this question, my lord. My humble prayer is, my lord, kindly set aside this order and remand back this matter to rehear the issue again, my lord.
Any authority?
My lord, no, my lord. I am on the act itself. I am not going into any authority. My learned senior has applied the judgment. My lord, I am on that only. Same put. I am not on the merit of the issue, my lord. Merit can be decided before the Lokayuta, my lord.
Yes.
Lokayuta has to decide whether there is a prima facie case or not. I am not on that, my lord. But my only contention is Lokayuta cannot go beyond the act, my lord, beyond section 20.
Yes.
So therefore, the second part may be struck off. I am okay with that. He is unhappy with the portion that helps him.
No, my lord.
It can be struck off.
My humble prayer is, my lord, kindly remand back this matter and a fresh hearing may be given, my lord, to me. So I can produce the case before the Lokayuta. My lord, I have filed a complaint, my lord. There is a prima facie, my lord. Kindly see the impugn order. Prima facie, the Lokayuta has accepted that in the inquiry also. My lord, if in a society construction work has been allotted to the VC functionaries, they have not started the work. Work is like this pending like that, and money has been disbursed. Then what amounts to corruption, my lord? That is the virus in our society, my lord. The corruption, it's rampant, my lord, everywhere. Which is why the intent of the legislation to constitute Lokayuta. Lokayuta, the purpose of Lokayuta is what, my lord? To find out the person who is involved in the corruption and initiate prosecution. So now Lokayuta violates the provision of section 20, and one hand saying there is no prima, I am satisfied that there is no prima facie case. On the other hand, he is recorded in the impugn order that the 3 construction work has not completed, money has been disbursed. On the third portion, Lokayuta, Honorable Lokayuta has directed the CNRD department to initiate action against the person who has released the money. So I'm failed to understand, my lord.
Yes, Mr. Sheikh.
Can I quickly respond?
My lord, he cannot, my lord.
He can. It's what he can. He can assess it.
My lord, no, he has to first set aside. He has to file a miscase on that,
we
my
can
lord.
submit. We can
Yes,
submit.
Lordship. Now, so far as the technical issues, Lordship, now what my friend is harping with regard to that second direction. So he is not agreed. That has been argued by learned senior Lordship. Now on merits, he has referred page 35 of the inquiry reports, which says that although in the records reflects the name of X, but the construction of well was taken place in the house of Y. My lord, in the report also it says that the RCC renewal lordship given not only a particular individual lordship or household lordship.
We're not going to go there.
Yes, lordship.
You're just going to go on same thing.
Yes.
So whether isn't it patent illegality in the order of the
My lord, yes, my lord.
of the local.
That is why, since yes, my friend has referred that is also one of the illegalities. The Lokayuta did not consider into that aspect also. Now 3 or 4 households, the renewal were given 3 or 4 households. Now suppose if one person is refused to allot the land for the construction of renewal lordship, obviously that will be shifted.
My lord,
to
I'm not even argue on that point, my lord.
another aspect, lordship. Now the last recommendation, lordship.
Yes.
Last recommendation. Kindly, lordship, the community and rural development shall cause an inquiry regarding the payment of wages to the job card holders. Now, the projects which my friend is saying that yet to be completed, but the money is disbursed to the job card holders, lordship. Now, the projects involve the construction of, lordship, RCC renewal, lordship. For construction of RCC renewal, lordship, there are 2 components of workers is required, lordship. One is labor for cleaning, earth filling and digging the well, lordship, and for materials, lordship, like rods and cement, lordship. So far as digging and earth filling and the cleaning of the place, lordship, I have to, the VC secretary have to engage the job card holders of the place. Now, under the Mandraka rules, Lordship, it mandates that the wages is to be paid fortnightly, Lordship. If there is a delay, Lordship, then the government has to pay the interest, Lordship, for delay payment of wages. Now, Lordship, now at the time of issuing the work order, the government did not release the fund, Lordship. Did not release the fund. And VEC did not have any fund on its own. Unless the department release the fund, Lordship, the VEC secretary cannot do anything. Now the job card holders, those who were employed for the digging as well as cleaning as well as earth filling, their master will be prepared and sent to the government. And government has accordingly released to the personal account.
We're going to go there, Mr.
My lord, my learned friend is diluting the matter, my lord.
That is his.
He's tried to dilute the matter. Not even his party. He is not even enter, my lord, in this matter.
Now how I am involved that
No.
money was credited into the personal account of
No,
the
my lord.
job card holders.
Now question comes here, my lord. How without constructing, I agree on my learned what my learned friend is saying. Now with regard to 1, 2 and 3, this construction work has not even started. Now how the VC secretary and president submitted the bills to the block development officer. Now question comes another, how block officials has transferred the money without even other parties. Okay, my lord, other part has constructed. I agree.
Authorities where the under 226 interfered with such findings?
My lord, yes, my lord.
You have the authorities?
No, I have not gone on to this,
Why?
my lord. Because, my lord, my only prayer, my lord, limited aspect is the violation of section 20, which is why I come before your lordship, my lord, with a direction to the honorable Lokayata to set aside this, or to set aside and direct, my lord, to give an opportunity to all parties, my lord.
Opposite to what?
To make a fresh hearing, my lord. No, not inquiry, my lord. On this inquiry report, since, my lord, there is a 3 construction work has not completed. Money has been disbursed. Now I put in question myself, my lord. What amounts to corruption?
But money only with regard to the wages, lordship,
No,
not the
no,
materials.
no. Now wages, how wages transfer to the account? Unless and until VC secretary and president make a bill and submit it to the department.
We'll give you one more opportunity.
My lord, yes, my lord.
Since he has brought his authority.
Yes, my lord.
Now you show under 226, in any other similar Lokayukta matter,
yes,
anyone, whether there has been any interference.
My lord, this honorable court has previously also has interfered, my
Where's the
lord.
judgment?
My lord, they have. I cannot recollect.
You should have come armed with the
my lord,
authorities if you want to
there is no such judgment.
My lord,
You get it?
No.
You get it posted.
No,
on
I'll get it, my lord.
Matters have been withdrawn, settled, etc. But
yes,
there's
so
been no
we'll
judicial
post it
adjudication.
I'll
post
get it,
this
my
matter on Wednesday to allow Mr. S.K. Hassan to.
My lord,
we'll
kindly
dispose of next day.
My lord, kindly give us, my lord, 2 weeks time, my lord. My lord, kindly, my lord. My lord, 2 weeks, my lord.
Why?
I'll did some research work on this issue, my lord. Kindly give us 2 weeks, my lord. Positively, my lord.
Because
okay, 1 week.
Positively, my lord.
My lord.
After 1 week. Yes.
My lord. Highly obliged, my lord.
Interesting matter. The thing is that,
yes, my lord.
see, the thing is, only one thing in your favor is that.
Yes, my lord.
Now, whether the Lokayukta,
yes, my lord,
when there's no prime facie case, whether under the Act,
yes, my lord,
it can issue, but then what he said under, what's it?
Manrega.
Yes.
Manrega.
Then he should have indicated as such in the order itself.
My lord, the other aspect, my lord, has to
second part
appreciate,
I'm
my
prepared to
lord.
put on record can be struck off.
My lord, the other issues, other part, my lord, has to appreciate. Honorable Lokayata has recorded in the impugn order 1, 2 and 3 project has not been started, which is recorded in the.
No, you find that thing.
I'll find, my lord. So these are the things Lokayata has to, which is why they are the expert body, my lord.
Yes.
Lokayata. And in case of corruption,
after 1 week.
My lord, highly obliged.